Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back on the forced reset trigger settlement agreement because while we applauded it and thought it was a momentous day for gun owners nationwide, not everyone shared that sentiment. And there are some out there that have been very critical of the settlement agreement. Now, I'm not here to stick up for the settlement agreement. I'm not here to pick sides, and I'm certainly not going to be naming anybody by names because everybody is entitled to their opinion. But what we are going to try to do today is something very consistent with what we're always trying to do, which is we're going to try to keep it right down the middle. I'm not going to tell you guys how to think, but I am going to give you some more stuff to think about. So today, let's spend a few minutes and let's talk about the realities of the FRT settlement agreement. Okay, America, so here's what we're going to do today. We're going to circle back on the FRT settlement agreement. Now, at the time that the news broke, I thought it was a momentous occasion. Could not recall any other time that a large Second Amendment organization had successfully sued DOJ and ATF such point that they settled to dismiss the lawsuits and give everybody their stuff back. I recognize that there were other people who were not as thrilled with this. And again, I'm not calling any of them out. I'm not saying they're idiots. I'm not saying they're morons. What I am saying is some of the criticism may be fair. Some of the criticism may be misplaced, but it may be misplaced because simply they hadn't thought of certain things or there was facts that was not available to them. So before I get into some of the arguments that were made, I want you to understand that there are certain caveats we're going to try to stick to today, and they are as follows. Number one, we're going to try to keep this right down the middle like we always do. We're going to apply the law to this litigation. Number two, we're not attacking anybody here. We are giving you just more stuff to think about. Honestly, many of the criticisms came to me from secondhand information because, believe it or not, I actually don't watch a lot of YouTube, okay? Between my law practice and then having to do the Washington gun law stuff and then also trying to be a husband and a father and have a little bit of good time once in a while, I don't spend a ton of time on YouTube, okay? And then the third caveat, and this is important, we are not addressing anything related to Rarebreed Trigger's portion of the settlement. And the simple reason is that I cannot speak to the unique circumstances that under which Rarebreed finds themselves. We do not know, unless you are one of the individuals who ran this company, owned this company, you do not know what has happened to them financially. You do not know what has happened to them professionally. You do not know what has happened to them personally, and any of the other fallout that could have come from this litigation. So unless you can put yourself in their shoes, okay, understand that what they got and what they gave up, that is something that I cannot speak to. I have never had a single conversation with any individual who works with or represents Rarebreed Triggers. Criticism number one, we could have had precedent protecting FRTs. Well, that would have thus required plaintiff's counsel to turn down a settlement that was offering to agree to dismiss the suits and return all the property seized from individuals. Now, that would be incredibly irresponsible lawyering if you are litigating to reach a certain point, and at that moment you are then offered to reach that certain point without having to litigate. The prudent attorney would advise the client to do exactly that. And as a matter of fact, there would be several bar associations that if you decided, nah, we're going to turn down the settlement agreement and go for broke anyways, why you even did that? And if God forbid you did that and then it didn't work out, well, somebody's bar card in their wallet's going to get pretty warm. Let us also remember the limited scope of what could have happened here. This was not a Second Amendment challenge to whether or not the government could ban forced reset triggers. No, this instead, as you recall, was about whether or not the ATF had the legal authority to promulgate new definitions of machine guns. As a matter of fact, if you take a look at any of the pleadings in any of the litigation that was resolved by this settlement agreement, you will not see the Second Amendment cited nearly anywhere because that is not what this litigation was about. So the ability to have some kind of huge, monumental, Bruin-like ruling as it relates to forced reset triggers, that was never, ever what was being litigated. And as one of the counsel wisely pointed out to me, you can only win the lawsuit that you file. But then let's say you decide for whatever reason that nope, we're going to turn down this settlement agreement and we're going to litigate it because dang it, we're going to make ourselves some Supreme Court precedent and this is never going to happen again. Well, if you could actually run a case all the way to the United States Supreme Court, and y'all know how difficult that is, okay? You could have gotten a ruling very similar to Cargill. That would have been really awesome. Or you could have gotten a ruling very similar to Vanderstock. Which one do you think you would have received? Number 2, the settlement is unenforceable. It's not worth the paper it's written on. The ATF won't follow it, and because there's no damage provisions. Okay, many settlement agreements come without damage provisions, and the truth of the matter is that any party to any settlement agreement is always capable of breaking it. All they have to do is actually break it. What the consequences of it are is oftentimes hard to determine until that breach occurs, and then we can calculate the egregiousness of the breach as well as the damages incurred. But if you look in the fine print of the settlement agreement itself, you will see that any alleged breach of this agreement will be handled by what court? That's right, the Northern District of Texas, the original court that granted injunctive relief in this particular case. And why we would have loved a settlement agreement that would have said that the ATF will never, ever, ever in the history of the world again attempt to enforce this regulation in this fashion. We all know that all it takes is a shift in political winds, and suddenly that agreement would be breached as well. Okay, and then let's remember this, that the only way that you can positively resolve a lawsuit is either through litigation and you win it, or it's through a settlement agreement that you clearly get the better edge of. And there is an adage that trial lawyers all teach other younger trial lawyers is it's always easier to stroke something out of a person than it is to beat it out of them. At the end of the day, when you take a look at who the plaintiffs were and what their goals were, they had to protect their interest. And that includes the National Association for Gun Rights, who was absolutely positively looking out for every single one of their members. And candidly, if you take a look at who's allowed to petition to get their trigger back, they went above and beyond because it's not limited to NAGR members, it's any person. So to be able to resolve a case in the exact fashion that your clients demanded, and to do so without litigation, well, that's a grand slam home run for any attorney who's actually representing those clients adequately. Number 3, the settlement agreement just gives way too much power and authority to Rarebreed Triggers. Okay, well, understand that there are 2 distinct parties here that are negotiating this settlement agreement, okay? There are plaintiffs, that is the lawful, responsible, gun-owning Americans who had their triggers taken from them, and then there is also the company that was producing these items. And clearly, they had different interests. I didn't say competing interests. I don't believe they had competing interests at all. But there are certainly the priorities of their interests would be different, and the attorneys for both sides would be cognizant of that. So understand that there are portions of this settlement agreement that only Rarebreed themselves could speak to, and as I mentioned at the start of this video, I am not speaking on behalf of Rarebreed because I have no authority to do so. I have no knowledge to do so. But for those who think that they could go out and patent troll, that this somehow or another gives them a technological monopoly, understand that that's the whole reason you have a patent. Okay. Also understand that when you read the language of the settlement agreement itself, it is very, very clear that it involves only one type of Rarebreed trigger, okay? And if there have been technological changes or technological advancements, the settlement agreement does not cover that, which means it does not necessarily make it legal because those could still be illegal. I'm not saying justifiably so, but in the eyes of the ATF, they could see it that way. The part of the agreement that requires Rarebreed to go out and enforce their patent is really asking anybody to do what they had invested tons of money and tons of time to do, which was obtain that patent. If you don't intend on enforcing a patent, then why go through the headache and the cost and everything required to actually obtain it? So listen, you may believe that the folks over at Rarebreed have some more explaining to do, and if they decide that that is necessary, and if they decide that that is appropriate, I will leave it to them. Finally, number 4, the settlement does not protect FRT handguns. Okay, so I'm not even certain if FRT technology is feasible inside a handgun, and I am, at least myself, not aware of any developments of FRTs, wide open triggers, Hellfire triggers, or anything like that to be used in handguns. There may be many other reasons for which Rarebreed chose to do that. There may be financial reasons, there could be patent reasons, there could be lots of reasons why they agreed not to do this. And one of those reasons could be that the technology is just simply not really feasible in that particular platform. So America, again, listen, can you criticize this? Of course you can. And is some of the criticism deserved? It very well may be. But at the end of the day, what you really had was two different interests here. You had a large Second Amendment organization that decided to negotiate not only on behalf of all of its members, but vehemently went to bat to ensure that every American can get their trigger back. And I think for that, they should be applauded. And then you have a different interest, which is the Rarebreed Trigger folks. But I think that unless you completely understand all the complexities that went into what Rarebreed went through, from a financial, from a personal, from a professional, from a spiritual, or any other way that it may have affected it, you may have understood, as their attorneys likely did, that there was some very strong desire to bring about an agreement, and there were certain concessions that would be made in order to get to that. And I think until all of that information is truly derived, the criticisms, while they may be fair, we have to acknowledge, are still a little bit underinformed. Okay, listen, I'd love to hear what all of you think about it. Again, I respect all of your opinions, and you guys may have thought of something that I hadn't, and sometimes I see comments and I go, wow, hadn't thought of it that way. You know the drill. If you want to talk about it, just go ahead and leave us a comment down there in the comment section. Okay, now if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information down there in the description box. If you got an idea for a video that we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, you take a look at that information because it's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.